We only have one case set for video oral argument this morning, and that is Kellie Ann Smith versus Michael Tyler Smith. Both sides will have 15 minutes to argue their case. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I will keep you apprised of when you're getting close to or into that rebuttal time, at which point you can decide to reserve the time or continue. Please do not mention the names of any victims or children if they're relevant to your oral argument. Just refer to them as child or by initials. We've read the briefs. We're ready to proceed when you are.
Thank you, Your Honor. May it please the court, my name is Leslie Grasky. I'm the attorney representing Michael Tyler Smith in this matter. I am sure the court is familiar with the previous filing in this matter, which was based upon the trial court's failure to grant 60B relief from judgment on a famously unfair and almost illegal separation agreement between these parties. Pursuant to that agreement, Mr. Smith was to pay about $84,000 in things that were not support so that mother could continue on Medicare when he was earning approximately $122,000. This court remanded this matter to Judge Quinn, and he dismissed the dissolution. As a result, mother filed this action for divorce, which proceeded to trial in December of 2019. The only issue before the court at that point was the allocation of parental rights and responsibilities, and excuse me, that matter went to trial for almost an entire day. The guardian ad litem testified significantly and prepared a report, which is Court's Exhibit 1. The record reflects that that report was transferred to the court, and I don't know how to verify anything beyond that it actually appeared in the court, but I am very anxious that the court review Court Exhibit 1 in the context of the guardian ad litem's testimony. The guardian recommended an equal time parenting schedule for these children and recommended that father be in charge of medical decisions and mother be in charge of educational decisions while continuing the children in their current school. The trial court ignored those recommendations, and the 24 hours of investigation, a minimum of 24 hours, because that's what she submitted a bill for, but it's quite clear that her extensive, excuse me, extensive investigation was longer than that, showed that it was in the best interest of these children to have a relationship with both parents. She expressed concern about the mother's interference with father and with the mother's credibility. The trial court relied on mother's claim that father threatened to kill her, and that would have happened in 2017, after which the guardian conducted a considerable investigation, reviewed police reports, interviewed the parties, interviewed the children, and some other important things happened. One, father was never charged with anything that would result in a conviction for threatening to kill her. The only testimony in this matter is mother, and people who say that mother told her that he threatened to kill her. The children, one child expressed that she had had a dream that father threatened to kill mother, and mother had turned that into a report that he had made the threat. CSB investigated that and found that it was unsubstantiated, and mother was convicted for her obtaining a false identity and making false allegations against father's business through social media. Twice after her conviction, the prosecutor actually filed motions to show cause why the original sentencing order should not be imposed, which would have given her some jail time. That's because she continued to pursue father, to go to places where he did business, and to interfere with his business relationships, particularly when he was asked to give a list of businesses. She then had subpoenas issued to all of them with the wrong Social Security number for Mr. Smith, and sometimes the wrong business name, and then claimed he was interfering with her ability to obtain discovery. This is not someone...
Counsel, can I stop you for just
course.
a second? You had indicated previously about father's prior conviction. You said, well, he was not charged with the threat to kill his wife, but he was nonetheless convicted of menacing.
Yes.
And so you're saying that was a different...
No, that is the event. This is 2017. And my client was at that point paying the $84,000 per year in mortgage and private insurance for mother, although the children were on Medicaid, and taking care of the pool and taking care of the lawn care and paying for home maintenance, even though mother was not working outside the home. He didn't have funds to obtain private counsel, and he took the best deal he could get.
Okay, I apologize because I remember reading in somebody's brief that there might have been two different incidents. Anyway, the second question I have that I don't want to forget before we run out of time is, father received the standard parenting order?
Yes, Your Honor.
Okay. Is there anything in the record that actually demonstrates that? In other words, I'm not sure we found anything in the record that says that what father's entitled to with parenting time.
I believe the decree of divorce assigns him standard order parenting time. I would be happy to submit that reference today and copy counsel so that the court could have that exact reference.
All right, thank you.
Thank you. The trial court rejected the guardian's recommendation of what she called parallel parenting time, claiming it was forbidden by Tustin and the 310904. Because the court completely misapplied the statute, this court has a de novo review of this matter. And it's significant because this entire record shows that it's in the children's best interest to have 50-50 time with their parents and to have the father actively involved. I don't want to reread my brief. I know the court has done that and will do it again, but it is replete with references. It's replete with mothers' attempts to manipulate the facts at all times. The guardian noted that mother lacked credibility. The counsel for mother withdrew, specifically stating in their motion that their representation would result in violation of the rules of professional conduct or other law. The client persists in a course of action that the lawyer's services, so that the lawyer the lawyer reasonably believes that her actions are illegal or fraudulent, and the client, mother, insists on taking action that the lawyer considers repugnant or which the lawyer has a fundamental disagreement with. Judge Quinn granted that motion on those bases. This woman has demonstrated that she will say what she wants to say to get what she wants. No Summit County prosecutor would have failed to pursue real charges against Mr. Smith if there had been a credible basis for prosecuting him. That is a serious charge, and it would have been pursued. And after that 2017 incident, there are numerous examples of mother interacting with father, bothering his businesses after she's been ordered by the criminal court to stop it. Her part of her second show cause order was that she obtained counseling. Her counselor testified and told the court that she had never heard that this counseling was because Judge Coates ordered it to keep mom out of prison. She was told that it was because mother was experiencing anxiety, and that was normal in a divorce and when you get convicted of a criminal offense. She did not know because mother didn't tell her, because mother says what's important for her, and that's not often the truth. The judge found items where there was no evidence, for example, that mother would be more likely to honor and facilitate parenting time. There is no evidence, not one word, about father interfering with parenting time. There are numerous examples of mother interfering with parenting time. The judge even said that father's child support payments were erratic. There is no evidence of that. The temporary order went on in May. It was backdated to March, and father paid all of his support the day the order went on. You can't go to CSCA and say, here's some money until there's an order. They won't take it. There is no evidence that he was erratic. If there had been, I'm quite certain that Ms. Smith would have been there with that evidence. Sedgco permits the allocation of parental rights as recommended by the guardian, and the statute permits that allocation of parental rights. That's why this matter should be given a de novo review with complete consideration of what the guardian ad litem recommended, her findings, and her analysis of these people.
Counsel, I need to let you know that there are about a little over 4.5 minutes remaining. I don't know if you wanted to reserve any time, but I wanted to let you know.
That's what I would like to reserve. Thank you very much, Your Honor.
Hello,
Your Honor.
we're ready when you are.
Thank you. May it please the court, Attorney Silas Pisani. I represent appellee and plaintiff in the trial court case, Kellie Smith. The first thing I would like to make the court aware of is a few points, so my client's position is clear to this court. The first is, and as you'll see in the record, as I'm sure you've read in my brief, with the history of domestic violence, the threats against mother, the father having supervised visits for 2 years. The first thing I want to let this court know is the sole purpose of this appeal is to harass Miss Smith, the mother of his children, and cause financial and emotional harm. Right after the trial court's decision was rendered, there was immediate motions filed in the trial court to change the decision that was already made. There are no factual accuracies in the court's April 21st, 2020 decree, as stated by appellant in their brief many times. There was no abuse of discretion by the trial court. The evidence is fully supported by the decision and vice versa. And I'm sure you'll see that in the record of the December 4th trial date. Here's why I believe, you will see that the court made the correct decision and the evidence supports that decision. Mr. Smith threatened to kill Miss Smith in front of the children and was arrested for that crime, despite Miss Smith not even wanting to press charges. Charges were filed anyway. In a father's brief, it's consistently stating that it's alleged crime. No, this happened. He was charged with domestic violence and he was convicted of menacing. Secondly, there was unrebutted evidence at the trial level that there were significant amounts of domestic violence committed against mother during the marriage in front of these young children. Even one time, and mother's sister testified to this at trial, a father choked mother while she was pregnant with their youngest child. Also, Mr. Smith had supervised visits with the children for over 2 years. This led to some of the domestic violence, but the last straw mother had was when she walked into his home, he was passed out drunk while he was to be caring for the children. This led to Mr. Smith having supervised visits for over 2 years. And he was just removed from these supervised visits just 8 months prior to the final trial date. So there's significant evidence of why Judge Quinn came to the decision he did. And the decision is in the best interest of the minor children. Mr. Smith argues that the court ignored certain evidence when coming to its decision. I think ignored is a strong word. Father particularly mentions they ignored the guardian ad litem's recommendation. When you look at the decision of the court, I can tell you, and you will see that right before the conclusions, Judge Quinn specifically states that he considered the recommendations of the guardian ad litem, but is not adopting them. Judge Quinn also states in his opinion that mother, when she does have a conviction, and you walk in any trial court, and I'm sure this court has seen numerous criminal appeals, but when you plead guilty to a crime, you are guilty. There's no excuses. You're admitting to that crime. Father in his brief is trying to say, oh, I couldn't afford a lawyer, therefore I wasn't really guilty. Miss Smith pled guilty. She owns up to that crime. But Judge Quinn, in his opinion, states that mother's behavior had more to do with father's business. Father's behavior had more of a negative effect on the children. So that's certainly something the court looked at when making their decision. What is in the best interest of these 4 young children?
Excuse me, counsel. So with all the alleged prior abuse and obviously the conviction of menacing, what was in the record pertaining to all that other than mother's testimony?
In the record, there was findings that father had threatened to kill mother in front of the minor children, and that.
No, I mean, I'm sorry for interrupting, but I'm talking about, was there any exhibits like the police reports from prior domestic violence? Were there actual certified copies of anything? I think neighbors talked about something about that. What
Yes.
type of evidence?
Yes, Your Honor. The evidence presented was a certified copy of the conviction and of the sentencing of father. Also, I did have a neighbor come in. It wasn't the neighbor that witnessed the first incident of father threatening to kill mother, but it was a neighbor that witnessed a child stating that she overheard father saying he wanted to kill mother, which I believe was a second incident. I don't know if the child was recalling the first incident or had the father said it again, but obviously it stayed with the child, or the child heard it again. So that
what year was the alleged "I'm going to kill you"?
The 2019 was when the child repeated it. The conviction happened in 2017.
Okay, so the child is, okay, that's maybe where I had some confusion, because it seemed like the conviction was way before the alleged threat.
Yes, understand, Your Honor, and thank you for asking. So again, father states in this brief that in the guardian ad litem kind of mentioned, but she corrected herself at trial. The guardian stated that she had credibility issues with mother. Upon my cross-examination, I questioned the guardian, is credibility the right answer? And she said, actually, credibility isn't the proper answer. She couldn't come up with a word for it, as I recall. But in this instance, mother was clearly the most credible witness at trial, and I feel strongly that that's why the court landed on the decision they did, other than the father threatening to kill mother and the domestic violence and the being passed out drunk while caring for the children. But mother was clearly the most credible witness of these 2 parties at trial. Father was sued by his employer for violating his non-compete. Under oath, father gave a laughable, unrealistic explanation as to what happened with that case. He said basically part of his duties were to order products from other companies under a fictitious name and have them delivered to his home so he could see where these products were coming from. He said that was part of his job, but that's exactly what he was sued for. I can't imagine any lawyer taking that case and saying, hey, we have a slam dunk non-competition case here, even though this was part of his job duties. So that was a clear lie under oath by father.
Was father fired?
Father was let go previously, and then Miss Smith found a package after they had been separated for some time with products and turned it over to his employer, who then investigated it.
And my understanding is there is no judgment against him?
That's what father says, but the agreement was never disclosed. There was a NDA in place. So I'm not taking him at his word, because, just based on the history of Mr. Smith, and I believe the lie that that was part of his job duty, but at the same point, that's exactly what he was sued for, is very strange.
Well, counsel, let me ask you a question here, if I could. You're saying you believe he was lying. He was lying. The other side saying she's lying. She's lying. in terms of just that issue, the job issue, for whatever it has to do with this case, how do we know he's lying? Did the boss come in and testify that that's not part of his job duties?
I mean, you just have to put it together that he was sued for the exact reason for doing his job. He was sued for non-competition. I mean, it just doesn't make sense that that's a frivolous lawsuit that's baseless. No lawyer's taking that case. So you just have to see, and there's an NDA and there was issues with getting that agreement, but it wasn't turned over, by father. We just have to take him at his word for it, which is his former employer hired private counsel, spent thousands of dollars for basically a baseless lawsuit. It doesn't add up.
And that's all on the record?
That father testified to that, yes.
You said that the employer spent thousands of dollars?
No, but he was sued by.
I understand. I just want to remind counsel, it's very important that we keep to the record, because it gets confusing to the court then, and we can't consider it anyway.
Father's explanation is definitely in the record. Secondly, father failed to file his taxes to the point where mother had to file for innocent spousal relief, which is very difficult to get. Mother testified that she had to prove that she was in an abusive and controlling relationship to even get that relief.
With respect to the tax returns, what relief is your client asking the Court of Appeals for with respect to that one issue?
I believe from my brief that the court didn't address that issue, and that was something that was brought up in trial. So I believe that if this case is remanded, that's the only issue that should be considered by the court. And my client asked that he be responsible for all the tax liability, as my client was not employed during the marriage.
Thank you.
Secondly, father misapplies this court's ruling in Tustin, Tustin v. Tustin. I know that citation is in my brief. That ruling stated that this court cannot, pursuant to statute, this court cannot allocate some parental rights to one parent and some to another. It has to be all parental rights to one parent. And essentially, father's asking that this court overrule their recent ruling in Tustin v. Tustin and order some parental rights to father and some to mother. That ruling that this court set forth essentially said that the court can only order parental rights to one parent, but father is asking that the court just ignore their previous ruling and do what the guardian recommended, which was parallel parenting. And the court could not, pursuant to Tustin, could not order parallel parenting as the guardian ad litem recommended, just because of that Tustin ruling, and it would be in contravention of the statute. There was a lack of investigation by the guardian ad litem while we're on that topic. She had not talked to the children since they had ceased supervised visits with father. So there were several issues that had arisen once supervised visits had ended, and the guardian ad litem failed to talk to the children for, I believe, a period of 8 months to see if anything has changed. So that's a significant issue. She had not talked to Holly Stump, the neighbor, who was provided by mother as a witness, who's heard one of the children say that a father wanted to kill mother. Also, the guardian ad litem, before Ms. Stump testified, stated, she would likely change her recommendation if there were a second time that father threatened to, mother. Why, the first time wasn't enough, I'll never understand. But the guardian did say she would change her recommendation. Ms. Stump comes in and testifies that she heard one of the children hear that from father. Finally, and again, I think I mentioned this earlier, but father's brief states that the trial court ignored the guardian's recommendation. It specifically states in Judge Quinn's decision, he considered the recommendations, but was not adopting those recommendations. And that's what the trial court found was in the best interest of these minor children. Also, the only evidence presented at trial of denial of parenting time was father consistently denying mother's nightly phone calls. It was, she would call and immediately it would be ignored. And sometimes the calls weren't even returned. Counsel for father states that there was a previous contempt filed by father. That was dismissed as unsubstantiated. There was no evidence that mother, denied any parenting time. The court said that it was likely that the parents just weren't communicating well. There was also evidence that we did file a contempt against father for not paying his support. There was also evidence presented that father regularly didn't pay his part of extracurricular activities.
Counsel, back to the support, the motion that was filed for not paying, excuse me, the support, what support was that referring to? Child support?
Yes, Your
And
Honor.
under what time frame? Because having been on the prior case, I don't recall there being child support.
There was temporary child support, Your Honor.
Okay.
Okay. Thank you for that question.
Well, wait a second. Let me follow up with that if you don't care. Temporary child support after the divorce decree was, after we remanded back to the trial court?
Yes. So what occurred is, and I wasn't on the previous one. I like to point out that this court upheld the last appeal because the separation agreement was, egregious and done by our previous attorneys. But the support in that case was mended. It wasn't direct payment of support. It was payment of bills, and
Yes.
it was egregious. And I understand the court's ruling in the previous decision. That counsel was let go, and luckily they weren't sued for malpractice from what occurred.
Counsel. We don't need to be editorializing on prior counsel.
Well,
Child support.
Yeah, child support. Thank you, Judge Callahan.
So there was a contempt filed. It was dismissed by the final decree, but that was filed and on the record for lack of payment of the temporary support. So there wasn't any support in the previous dissolution, which Judge Quinn dismissed. But Ms. Smith refiled after this court remanded the case and the case was dismissed. There was a temporary orders hearing where there was agreement of support for $13.50 per month.
Well, I need to let you know if your question, excuse me, I need to let you know that you're at the end of your time. If you want to sum up, unless the court has any additional follow-up questions and seeing none, if you could just sum up, and we need to.
Yeah, so again, there's no abuse of discretion. The evidence fully supported this decision. I know there has to be deference given to the trial court. Judge Quinn saw the witnesses. There was an attempt to on the record to get the parties to settle, but Ms. Smith did what was in the best interest of her minor children, went on with the trial. Judge Quinn made the correct decision. And it was based on evidence, and there was no errors of fact in that decision. I would ask that this court uphold that decision and let these children and these parties move on. Thank you.
Thank you, counsel. Ms. Grasky, you have 4 minutes and 25 seconds, but you first need to unmute yourself.
Thank you. I am now unmuted. I'd like to turn first to the lawsuit. Mother admitted that she instigated that lawsuit by going to father's employer and starting it. The boxes, photographs of which are in the record, show that the purchases were made during the time he was employed. He was not terminated. There is nothing in the record suggesting he was terminated. That's another misstatement. The only testimony is that there was no payment by father. There is no evidence in this record to show that he had engaged in anything that was wrong. Only the person who claims to be so frightened of him started his employer in a lawsuit against him, which was dismissed. There is no evidence in this record of mother needing to get innocent spouse relief. There is evidence on the 2014 tax return. Father hadn't gotten a 1099, so he didn't attach it. He was working on that. The high drama of innocent spouse and domestic violence was not necessary. All of the mother was allowed to go on and on about alleged abuse. But it was prior to the court's decree of dissolution, which gave him half the time. That was not credible, that he was a risk to these children when she agreed that he could have the children half the time in the previous dissolution separation agreement. The supervision started, yes, because mother was able to get him arrested for domestic violence, but the supervision order provides that he has to get counseling or get a psych eval, which he did, and that's in the record and that's in the guardian's report. He had to get a physical, which he did, and that they should start co-parenting counseling. That is in the record through the guardian and through the report from Summit Psych, that mom wouldn't even let him talk in the first session. So they terminated it because of her aggressive behavior. CSB investigated the purported threat to kill mother during the pendency of this case and found it to be unsubstantiated. The guardian, who met the children, met both parents, and testified that she called every witness mother gave her. Holly's testimony was post-report, and so I don't even think the guardian could have talked to her prior to writing the report, since she said the incident happened afterwards. The reason that there was supervision is that the mother would never recognize that, okay, you wanted a psych eval, here it is. You want a physical, here it is. You want co-parenting therapy, but then she wouldn't participate. The guardian testified that she had a credibility issue as to mother, and then it went on to some things that she would not call credibility. She never took back her statement that she had credibility issues with mom. She expanded on the concern she had about how mother treated dad on Our Family Wizard. I've addressed these issues in my brief with the page references of where these things happen. There are many things that we've just heard about that are not on the record. Mother claiming that the sister saw some kind of domestic violence. She heard on the telephone, she says, father choking mother prior to mom agreeing that he can have half the parenting time. It's simply not credible. And this matter should be considered de novo because Sedgco is the parallel parenting case. Tustin is the case that says you can't require the parties to make joint decisions if you don't have shared parenting. Tustin doesn't apply to this case at all. Sedgco expressly authorizes, as the statute does, the allocation of parental rights and responsibilities between two parents, even without their making decisions together. Because the court did not properly apply RC 310904, this court should conduct a de novo evaluation of the evidence in this matter, in particular, the guardian's report. The one neutral testimony in this case is the guardian who spent—
And counsel, with that, I need to let you know you have also utilized your time today. Thank you both
very
for,
much.
Thank you. Thank you both for your presentations today. The court appreciates your appearance by video conference. We will take the matter under advisement and we'll issue a written decision to all parties to this appeal, as well as it will be posted on the Ohio Supreme Court website and the 9th District website. Have a good day. Thank you.
Thank you all.